Mark asked letters of administration or letters of testamentary. So I think
So,
we use.
yeah. Okay, let me explain one thing. Okay, if I die in California and I created a will, a valid will that is signed, notarized, dated, and witnessed by two people, I see these wills like, oh, my husband had this amazing will. And I read it and I'm like, well, it wasn't witnessed by two people over 18, you know, or I got a will once that was notarized, signed and dated. That's not a valid will. So they don't care how pretty it looks. If it's not valid under the law, it's not valid. But if you have a valid will and you die, that's the difference between the two terminologies. Letters of administration is when I die with obviously no trust and no will. Letters testamentary is when I die and I have a will. What we do is we go, here, Your Honor, here's Shadi's will. This is who she wants to be in charge. This is who she wants to get her stuff. By the way, her will says no bond. Here you go. And if the judge wants, by the way, this is the judge's world, not ours, which sucks. Because trust me, the will could be perfect and the judge might go, well, you know what? I know Bill said he doesn't want you to be bonded, brother, but I want you to get bonded. And these are my reasons why. So, you know, but that's the difference between the distinction for the two. When you have a will with a trust, that's where it's called pour over will. When you have no trust and a will alone, that's just a will. And the pour over will just says, hi, I'm here because I have some certain legal significance, but go see my trust. Everything's pouring into my trust. When you've got the trust and will together, the trust is the big kahuna. The trust is the boss of it all. Let me tell you something. The trust is the best thing you'll ever get in this life in California, related on this subject. I'm very pro trust. I'm anti anything else. And like I said, I make way more money in probate than doing trust. But I want people, because it's private. A trust is a private document. All your affairs aren't going out in the public. So it's a huge distinction. Another thing a will does, a couple other things, but I don't want to get too much into the forest, is it talks about funeral arrangements, you know, cremation, burial. Very important for people with grandchildren or minor children. Me as a parent with minor children, my will says, by the way, my children's guardians are this person and this person. That is huge. Just so you guys know, if I didn't have a trust, I'm going to just kind of break it down. A lot of people don't have estate plans, right? They don't even have powers of attorney, financial, durable power of attorney, and healthcare directives, right? If I go home tonight and get hit by a car and I'm in a coma, who can sign my checks? Who can keep on the lights of my business? Who can write my mortgage? Who's going to pay the mortgage, pay the utility, all that stuff, right? Who's going to make decisions for my healthcare? If I don't have those documents, guess what my family has to do? They have to go hire an attorney. Right there, you're already losing. I mean, I'm not trying to offend attorneys, but you're already like, your loved one's in the hospital. Now you got to call an attorney. Like, who wants to deal with that? And now the attorney is going to say, okay, Shadi, give me $10,000 because that's how much it costs to now go and file for a conservatorship. And now they're going to,
and then they're going to charge for guardianship for your kids.
Oh, that's the other thing. So then if I go on date night and my husband and I get in an accident, my parents who are taking care of my children right now will always take care of them. The judge is going to be like, I don't care that you always take care of them. You need to be appointed as the guardian. You could be a crazy person. You could be an alcoholic, right? You know, if Shadi and Luke decide who wants to be their guardian, well, we're not going to question that unless they give us reason to. But otherwise, if they didn't put the plan in place, now as the court, we have to protect everyone and oversee all these things. $10,000-$15,000 cost total for conservatorship court. Yeah. So I'm always like, why do you want to even go through that? I mean, if you think about it, a trust avoids conservatorship court, that's 10 to 15, an initial probate, that's $3,000 plus all the additional fees. If you have children, you're avoiding guardianship proceedings. There's so many moving parts to this that makes your life huge. I mean, Medi-Cal, you can have an aging spouse who needs to get on Medi-Cal, right? Or you could be a young person and get in a horrible accident and you need some serious rehab or treatment, and someone in your family needs to go to the government and say, hey, we need help. They're going to be like, well, who are you? So, you know, it's not just about, you know, real estate and money and things. This is like about our own desires of what we want for ourselves. And that is so, so, so important. And that is all a part of a comprehensive estate plan. So, you know, when you go to an attorney to do a trust, all that should be included. Should never be in my opinion, piecemealed, but everyone has a different approach, I suppose.